themselves that they can live with it, the odds are far better that the case will be over and they won't come back to court. The statistics show there was a study done by the AOC that litigated matters all the way through trial have twice as likely an opportunity to come back to court than those that where people buy into the end result and say, I can live with this. They go all over the map. I mean, I remember divorcing one couple the day they were married. You can't ask them why, but apparently something happened at the wedding that was so serious, she decided to get a divorce. All the way to people that have been married for 50 years, and kids, without kids, all right. There's no typical case. Each one, and that's one of the beauties of our court system too. I think we're all trained to recognize the individual nature of each case, and it's treated individually.
Now, within the divorce arena, what are the different steps, the basic process that people go through?
Sure. Well, let me start at the end. The recommended period of time in which a divorce should take is 12 months. That's the ideal that we all try to work towards. The process starts with the filing of a complaint, then there's an answer, as you know, and then shortly after that there's what's called a case management conference, where usually a staff member in the family division will get the attorneys, if there are attorneys, on the phone, and we'll ask what are the issues. Let's put a timetable on discovery. And as you know, discovery is the period of time which the parties exchange information which is necessary to reach resolutions. If there's a pension plan, how much is it? What's it worth? Is there business? Does it have to be valued? Are there bank accounts? And that process is set forth in a case management order. Are there experts needed? Oftentimes, if custody is an issue, a custody expert is required or encouraged. Mm-hmm. Business appraisal might require a business expert. Those kinds of things. And then the order is signed, and then the parties go on their way. The next real step in the process is between 6 to 8 months. We try and get people in for early settlement panel, and as you know, that takes mm-hmm. place in Morris every Wednesday. Early settlement panel is a process. In Morris, we usually have 3 panels of 2 lawyers each, and they're volunteer attorneys, people that do family law and practice in Morris County or Sussex County. And there are statements that have to be required to be filed the Friday before. The litigants and the lawyers meet with these panels, and they get recommendations. And this is really the first time most people get objective thoughts about how a judge might decide their case.
2 neutral attorneys.
Correct.
Look at the settlement proposals, and then they recommend something they think a judge might order without
Correct.
having to go through a trial.
And one of the wonderful things that I think the bar, a lot of times lawyers are not recognized as being public servants, and they're not. Of course, they're out to make a living, just like we all are. But these are all volunteers, and we have 6 every single week, 50 weeks a year. So if you multiply that by the number of hours that it takes to do a case, the preparation time, that's a really substantial amount of contribution to the public good. And the bar should be praised for that, and we certainly recognize that.
That says something for the makeup of the family lawyers. They all they jump on this stuff. They love it.
Yep.
They can't get enough.
Yep, I agree.
Right. So after early settlement panels, where does the divorce case go?
The next step in the process is mandatory economic mediation. There is a statewide program where before they leave the courthouse that day, there's a 2-hour mandatory economic mediation, which is free. Again, 1 hour of preparation and 1 hour of actual mediation. There's a list of attorneys who have gone through the approved process to become mediators, and then the attorneys at the ESP or afterwards pick the mediator, the appointment is made, and then they leave with the order. That's mandatory for the 2 hours. After that, it's voluntary, but there's a charge, whatever the lawyer usually charges. And I should mention this too, about 50% of the cases that go through early settlement panel resolve themselves with the help of the panelists. Economic mediation, it's between 65 and 70%, very high percentage. If that doesn't work, the next step in the process usually is to work with a judge in what's called intensive settlement conference. And the lawyers will work informally with the judge, as you know, in chambers, again, trying to reach resolution that the parties can agree to. And in the unlikely event that they can't, then the case ultimately gets tried. And hopefully this is all completed somewhere between 12 and 15 months.
Any estimate on how many cases or percentage of cases actually go to a trial?
1%.
Yeah. A
little bit less than 1% statewide.
That's a small percentage.
It is, and that's a compliment, I think, to the process, because we do encourage settlements, and to the attorneys who, by and large, work very hard to help their clients understand what the law is and what their obligations are, and help them buy into accepting the settlement that's fair, hopefully fair to both sides.
Now, that's the area of dissolution or divorce.
Right.
There's another area called non-dissolution.
Correct.
And what cases fall into that category?
Well, as I said, they could be people who were never married but have children, and one party's not paying child support or the other party thinks it's not enough. There's an application for child support. Custody issues are resolved that way. Grandparent visitation issues. That's principally. And even if people are married but choose not to file a complaint, they still have access to the court if needed to get a custody decision and a child support decision.
Typically, it's the same type of issues in the dissolution, but the people aren't married.
Correct. There's also a far larger percentage of pro ses in non-dissolution than there is in dissolution, which makes it frankly difficult for judges that do non-dissolution because they don't always get the information, the best information to make the best decision. There's also a very active mediation program which has been very successful. That's a new program that's been moving through the state. We adopted it about a year ago. We use law clerks and others, mediators, to help resolve these issues. A lot of times the issues will resolve themselves if people have somebody to communicate with. They express each point of view and the suggestion is made and, oh, okay, that's good, I can deal with that. They accept it and move on. And again, same process. If they buy into the agreement, it's much more likely to be an enduring and appropriate agreement.
And those are in the non-dissolution type cases.
Correct.
Right? In the dissolution cases, you have a more formal
Correct.
early settlement panel and, and an actual mediator.
Exactly.
Okay. The next largest area may be juvenile?
Probably, yeah, I think that's right.
And what, describe the juvenile system within the family court.
Okay, it's fairly complex, actually. The whole concept of a criminal act committed by a juvenile is that he's not a criminal yet. He's too young to buy into being designated as a criminal. And it's a small diversion, but there is a process by which if a juvenile commits a serious enough crime, there's an application, he can be moved into the criminal court. So it's not just automatic that he's handled in the family court. But the principle of a family court juvenile matter is to try and help him overcome this particular incident and get on with his life in an appropriate way. And again, there's a great number of diversion programs. Some of these can be handled at the municipal level. Some can be handled by the Juvenile Conference Committee. Again, not too many of them actually get to the judge to be tried. There's a real attempt with a juvenile to try and help him or her grasp the significance of what they've done, overcome and get back on track so that they don't have the stigma of a major criminal conviction. The process is very different.
So a juvenile is charged with an offense. How does that juvenile work through the system?
It depends on the level of the offense. It could be handled at one of the diversion programs at the municipal court or juvenile conference. The more serious ones are handled by the criminal court, by the family court.